Justice Barrett.
I have some questions about the implications of your theory. So how would your theory play out if we're talking about 6-year-olds, where there's no difference between boys and girls in terms of athletic ability, testosterone levels, et cetera? Could you have sex-separated teams then? Or sorry, sex-separated teams by biological sex and not allow trans girls on the...
Certainly, Your Honor. First, I'd like to explain how the statute applies to that situation so I can put my answer in context. There are no 6-year-olds in the state to whom the statute applies because there are no school-sponsored
That's why it was a hypothetical.
Okay, right. Yes, like it would be the normal intermediate scrutiny analysis. And are we saying it applies only to 6-year-olds or to everybody across the board?
Well, I'm just trying to give you a I mean, yours is driven by testosterone levels and differences in athletic capability. So I'm asking you, what if you try to take that out of the equation and you're just drawing the line based on biological sex and saying that trans girls can't be on the girls' team in an age group that's prepubescent?
The record in this case does not support the notion that males lack an athletic advantage at 6 years old. That's about as early as the science goes from what's in the record. And even at that age, males have about a 5% athletic advantage over girls in most situations. Now, if this is not a level of competition where anybody cares about that, the simple solution is the solution you see in most places, which is you have co-ed sports, you don't divide the teams based on sex, and everybody can play. And Idaho's law does nothing to interfere with that.
And remind me whether Idaho's law, and I guess your answer made me think of this, and I guess this goes to the question of whether the law discriminates on the basis of trans status. Is it true that biological girls, trans boys, can play on boys' teams?
Anyone can play on boys' teams, Your Honor. Anyone
can play on boys' teams, okay. And to this point about medical uncertainty and scientific uncertainty, you were talking about what advantages you might have even that are apart from testosterone levels. Mm-hmm. Your friends on the other side say that, listen, that science is uncertain and so we need more factual development. It's not really clear how much of an athletic advantage boys and men have if their testosterone levels are below a certain point. How does that play out? Tell me why we don't need more fact-finding, or what is the state's burden in showing what the state of scientific certainty is? Do we have to defer to the state? Presumably at some point, if deference is due, the state would have too little scientific evidence to really get that deference. Tell me how to think about that.
The first question would be, are we applying intermediate scrutiny? And we argue that the court shouldn't. But leaving that aside, if the court is applying intermediate scrutiny, then we'd say it's Turner Broadcasting that says the legislature, First Amendment case, applied intermediate scrutiny and said under intermediate scrutiny, the legislature has to draw reasonable inferences from substantial evidence. It does not need to act only on scientific consensus, which is what the district court in this case assumed incorrectly.
Thank you.
Justice Jackson?